Good evening. I know we have more coming in. We are delighted to have such a large audience. It's exceeded our expectations, but once again, it's just a delight to see so many of you here. So welcome to the University of Tennessee. My name is Josh Dunn, and I'm the Executive Director of the Institute of American Civics, housed at the Baker School of Public Policy and Public Affairs. Tonight's lecture is the first of 3 Baker School Fall Lecture Series events aimed at exploring important topics that will be impacted by the November 5th presidential election. Tonight's lecture puts the Supreme Court in focus. This is fitting as this is also Constitution Day, which we celebrate. On this day in 1787, the Constitution was signed in Philadelphia by the members of the Constitutional Convention. Now, for better or worse, the Constitution has become closely associated with the Supreme Court as the ultimate and final interpreter of the Constitution. So as Chief Justice Charles Hughes said, we are under a Constitution, but the Constitution is what judges say it is. So that makes how justices interpret the Constitution of supreme importance. So, this quote, again, emphasizes the seriousness of the court's power, and tonight's lecture, Originalism, the Roberts Court, and the Future of Constitutional Interpretation, explores originalism as a guide for constitutional interpretation. The importance of originalism is reflected in the increasing number of distinguished scholars who study its development and application by Supreme Court justices. Tonight's speaker is at the top of that list. Keith Whittington is the David Boies Professor of Law at Yale Law School. His teaching and scholarship span American constitutional theory, American political and constitutional history, judicial politics, the presidency, and free speech in the law. Professor Whittington spent most of his career at Princeton University, where he served as the William Nelson Cromwell Professor of Politics. He's also held visiting appointments at Georgetown University Law Center, Harvard Law School, and the University of Texas School of Law. Please join me in welcoming Professor Keith Whittington to the University of Tennessee.
So I appreciate y'all coming out, and I appreciate the invitation to be able to speak to y'all today about these, at least I find, very interesting questions about how the Constitution works, how we ought to go about interpreting the Constitution, and what the future of the court and constitutional interpretation might be. I hope to make sure I save some time toward the end to take your questions, and so I want to hear what's on your mind about these issues, so be thinking about that. But I want to try to set the table some by thinking through how to think about constitutional interpretation more generally, what originalism is, and then a bit about the current situation on the court and the kind of alternatives that might be available for thinking about these sorts of issues. There were many unanticipated features of how the U.S. Constitution would work in practice that the founders knew would only be developed out over time. There were some features of the constitutional system that they felt like they had something of a good handle on and could anticipate what our constitutional practice might look like. There are others that were much less clear. And part of the reason for that is because the entire idea of living under a written constitution was extraordinarily new. It was essentially invented by the Americans after the American Revolution itself. And in the years between the Declaration of Independence in 1776 and the ratification of the U.S. Constitution in 1787, the United States saw an extraordinary outpouring of constitutional creativity occurring. And most of that was occurring at the state level. Of course, prior to the U.S. Constitution, we did have the Articles of Confederation that helped structure how the federal government operated during that time period. But most of the real constitutional activity was occurring in the states. After 1776 or after the Declaration of Independence, both by Congress in what we know of as the Declaration of Independence, but there were also many declarations of independence being issued by state governments as well, and in some cases by counties and cities. Those states also went about the task of trying to draft a new constitution in order to structure how their government ought to operate moving forward. And they did this in part because they had a vision about what a free form of government ought to look like. They believed that a free government with a free society required a limited government, a government bound by rules, a government in which even government officials were constrained by law and simply couldn't exercise pure will relative to their political subjects. And so they thought it was important not only to establish a functioning government in the midst of a revolutionary war, but also to establish rules under which those government officials would have to live. And part of what they discovered was that process of constitution writing is extraordinarily difficult. They made mistakes, things that they learned were mistakes over time. Many of those constitutions were thrown out and redrafted and rewritten or dramatically amended in many cases, such that we've learned a lot about what kinds of constitutional institutions might work and what might not. But there was also quite evident to that founding generation in those early decades of the American experience, a real recognition that there'd be more that we would learn going forward. And among the things that was very unclear and that they were just beginning to experiment with and beginning to think through was what it would even mean to live under a written constitution. What would it mean to live under a constitution that established rules and laws that government officials themselves would have to adhere to? By the time the Constitution was drafted in 1787 and ratified shortly afterwards, it was already beginning to emerge in practice at the state level that one implication of having a written constitution, a constitution that was taken to be a law that was binding on government officials, was the possibility that courts and judges might interpret that constitution and then require government officials to live up to those legal regulations. They might declare that actions that government officials had taken were in fact inconsistent with the terms of those state constitutions, and as a consequence were not legally binding and were not enforceable in courts. And this was something that those who were drafting the federal constitution were aware of, they could anticipate, but even this was very much an emergent practice that they were just beginning to see how it might operate. The other thing, of course, that from their perspective they recognized is that constitutions often didn't last very long. They didn't last very long at the state level. They'd already seen states rewriting their constitutions, abandoning their constitutions for new ones, even in very short years after they had adopted them. The Articles of Confederation they knew was flawed and needed to be replaced by the U.S. Constitution. They hoped that they'd already learned some important lessons about constitution writing, such that their effort in 1787 was better than the effort of other earlier constitution writers. But they recognized that they might well be making mistakes as well, and that their constitution also might not endure. But it turns out, of course, that the federal constitution of 1787 has endured. And so we now find ourselves in a situation in which we are grappling with how to govern ourselves under an extremely old constitution, a constitution that was drafted in a different time, a constitution with language that may include terms and phrases that are unfamiliar, a constitution which is layered onto our existing political practice in sometimes awkward ways. And moreover, we have discovered that judges take an increasingly important role within our constitutional enterprise. They may have been aware in 1787 that judges might sometimes be called upon to interpret and apply the Constitution, maybe even called upon to declare that some actions that government officials had taken were legally void, but they didn't anticipate how frequently that would occur, how significant it might be within the operation of the constitutional system as a whole. And over time, of course, the courts, both at the state level and the federal level, have become much more important political actors within our system as they try to think through what our Constitution requires and how it ought to apply to day-to-day practice. Well, this combination of living under an old constitution and having courts and others attempting to interpret what that constitution means and apply it in practice poses real kinds of challenges. And among those challenges is how do we preserve an old constitution of that type? How do we effectually go about interpreting and applying its rules and principles to new unanticipated situations as they arise? It also creates potential problems of political discontents that might arise with an existing constitution. So maybe we're not so happy with the constitution that we've inherited or that we have in writing, and how should we go about responding to those discontents? Should we follow the model of the founders themselves and the founding generation of rewriting constitutions and replacing them with new ones, or should we amend them, or should we try to do something else? One thing that has also occurred over the course of American history is we have fallen away from the practice of simply rewriting constitutions. Across the 19th century, writing constitutions was fairly common. Across the 20th century, it became quite uncommon. Even at the state level, states became quite reluctant to rewrite their constitutions even when they were unhappy with them. In some cases, they were able to devise new methods for amending their constitutions, so it didn't seem necessary to rewrite their constitution from scratch. In other cases, they found it was simply extraordinarily politically difficult to get the kind of agreement to write an entirely new constitution, no matter how unhappy they might be with the old constitution. So what we often find ourselves falling back on is a challenge of how do we interpret an existing constitution, an inherited constitution, a very old constitution, so that it still applies and can still be useful for guiding us in the present. And there have been lots of ways of trying to think about this over time. And one very prominent and influential school of thought that emerged in the early 20th century was to think of the Constitution as a kind of living organism. That the way in which we would deal with the fact that we have a very old Constitution is to think of it as a document that's going to evolve and change over time. It could be adapted over time. And one of the leaders of this movement was Woodrow Wilson, as a young political science scholar at Princeton University. He eventually, of course, becomes president of Princeton University and then president of the United States. But before he took on either of those tasks, he was involved in a revolutionary academic project of trying to rethink how the American constitutional system works and how it ought to work moving forward. And from his perspective, we ought to think about the Constitution not simply as a single document that was written in the 1780s, but rather as a set of practices and customs and ideas that were constantly being contested and constantly developing over time. So as he said in 1908, whether by force or circumstance or by deliberate design, we have married legislation with adjudication and look for statesmanship in our courts. That we have turned to judicial actors as the prominent interpreters of the Constitution, as those who are going to have to engage in a kind of statesmanship-like enterprise of maintaining those old constitutions and carrying them into the future. And that process is not going to simply be a traditional process of adjudication, the kind of things that courts are going to be otherwise familiar with, but will involve a type of what he called legislation. That is, courts would effectively be making new rules, new laws as they were moving forward that were then going to bind the government moving forward. That's the task we have fundamentally created by creating a system of judicial review combined with a written constitution. We have effectively created an extraordinarily powerful judicial system that had the authority to create new constitutional rules as we moved forward. And then the debate would simply be, what should the court do? What should those new constitutional rules look like? Well, this was not only the view of progressive scholars like Woodrow Wilson and those on the left of the political spectrum more generally. This basic idea was widely held across the political spectrum in the United States in the early 20th century, including embraced by many conservatives at the time. So James N. Beck, who was the Solicitor General of the United States under multiple Republican administrations in the early 20th century and a very prominent conservative lawyer in the early decades of the 20th century, said in 1933, the Constitution, from his perspective, is a living organism, susceptible to adaptation and therefore of increasing growth. And its vitality depends upon its correspondence with the necessities and spiritual tendencies of the American people. The Constitution, even from Beck's perspective, even the perspective of a conservative lawyer, was something that was going to have to grow and evolve over time. It was something that was going to have to match up with what the spirit of the American people were at a given moment. It was not something that was captured in amber at some particular historical moment, but was something that was always moving forward. Now, Wilson and Beck had very different ideas about what kinds of principles and commitments ought to be guiding us as we move forward, but they thought that it was inevitable that the Constitution was going to be understood in this way. And that vision of how to think about the Constitution, how it ought to operate, how we ought to go about interpreting it or adapting it, as the case may be, and what the role of the courts ought to be within that system, carried across the 20th century and continued to influence not only judges, but scholars and politicians for many decades afterwards. So one prominent, but perhaps a slightly extreme example of this is Mark Tushnet, who was a leading figure in developing the critical legal studies movement in the 1970s. As a young scholar, he just recently retired from Harvard Law School. But Tushnet was deeply critical of many theories of how the Constitution ought to be interpreted. And he said in 1981, I inevitably asked, well, yes, but how would you decide X case? You're always criticizing how courts and other legal scholars think about deciding particular constitutional disputes. What would guide Mark Tushnet as he thinks about how to respond to a particular constitutional dispute, and how would he prefer courts and judges to adapt to particular constitutional disputes? And Tushnet says, my answer in brief is to make an explicitly political judgment, which result is, in the circumstances now existing, likely to advance the cause of socialism. So from his perspective, the ultimate goal of courts is not to be thinking too hard about what the text of the Constitution actually says, not to think too hard about what principles the Constitution itself embodies. His view is that the core commitment of what courts ought to be doing is to try to figure out how to advance the larger political project of the American people, which from Tushnet's perspective was ultimately going to be a political project of socialism. And as a consequence, courts ought to take whatever steps are necessary in the particular context of particular cases in order to advance that larger political project. The constitutional interpretation, constitutional adjudication by courts was fundamentally a political task. And it was a political task in which judges were working hand in hand with activists and other political actors in order to advance ultimate political goals, whatever they might happen to be. In his case, it was socialism. In somebody else's case, it might be something else. But fundamentally, he thinks that's what all judges are doing all the time. And moreover, they ought to be more explicit about what they were doing. Part of the challenge of the 1970s and 1980s was a real reconsideration of this vision of what courts do and how the Constitution ought to operate vis-a-vis the courts. And in particular, it was seen as increasingly politically unsustainable to talk about courts in the kind of way that Mark Tushnet was talking about courts. If you simply told the American people what judges are political actors who ought to simply be doing politics from the bench all the time, most Americans would be very unhappy with that turn of events and that role for judges more generally. And so increasingly, legal scholars began to rethink this emphasis on living constitutionalism that had dominated American scholarship and American jurisprudence through most of the 20th century, and began to think maybe we ought to go back to thinking about the constitutional text and how to actually interpret the Constitution text. And so there was a massive interpretive turn in which there was a return to thinking that what the role of judges ought to be, and of constitutional scholars more generally, is not imagining what kind of political world you would like to live in and then trying to figure out how do we best get there, but instead trying to understand the text in front of you, interpret it the best you can according to appropriate interpretive rules, and then rule accordingly in the cases in front of you. So Thomas Gray, who was a professor of law at Stanford Law School, wrote not too long after Tushnet, as he characterized it, "We are all interpretivists now. The real arguments are not over whether judges should stick to interpreting, but over what they should interpret and what interpretive attitudes they should adopt." The kind of political project, the kind of jurisprudential project that people like Mark Tushnet was putting forward, people like Gray increasingly thought was collapsing. And instead, what we ought to recognize is that kind of approach to thinking about the Constitution was not going to be viable. We need to all be thinking about how do we interpret the Constitution. And there was a lot of disagreement about what that might look like. One of the most influential figures of this period was Ronald Dworkin, who was a scholar writing in the 1970s and 1980s in particular, and as he said, any recognizable theory of judicial review is interpretive in the sense that it aims to provide an interpretation of the Constitution as an original foundational legal document and also aims to integrate the Constitution into our constitutional and legal practice as a whole. That is, the activity of judicial review was to try to understand what our Constitution means and requires, and then make sense of it in the context of our larger political system. This move of rethinking the commitment to interpretation in some ways recurs back to the 19th century and how judges and legal scholars talked about what the legal enterprise was, including the constitutional enterprise was, from early in American history. Francis Lieber was one of these very early legal scholars, perhaps the most prominent legal scholar that existed in the early and mid-19th century, who did not himself hold a judicial position. He was simply a professor of law as well as a prominent social scientist and professor of philosophy. Ultimately went on to hold important roles in government over time. But among the things he did during his career was articulate what a theory of interpretation ought to look like, and bring to Americans in part a more sophisticated vision of interpretation that was based in part on continental theories about how to go about interpreting text generally, including legal text specifically. And as Lieber said in 1839, interpretation is the art of finding out the true sense of any forms of words, that is, the sense their author intended to convey, and enabling others to derive from them the same idea which the author intended to convey. That ultimately the act of interpretation was engaged in a process of communication. It was trying to understand what somebody was telling you. And in the context of text, that meant what were they trying to tell you when they were writing this particular text and then communicating it to you? And that would be true not only of personal correspondence that you might receive from somebody else, that was true not only in the context of conversations you might engage with another person, but it was also true of legal text in general. They were forms of communication from those who were authorized lawmakers, who were authorized to make rules, and the job of a judge was to understand what rules were those authorized lawmakers trying to put in place, and then trying as best they could to faithfully interpret those commitments and put them into practice in the cases that came before them. So, for example, as the New York Supreme Court said in 1852 in one of its cases, whether we are considering an agreement between parties, that is to say a contract, a statute passed by a legislature, or a constitution, with a view to its interpretation, the thing which we seek is the thought which it expresses. To ascertain this, the first resort in all cases is to the natural signification of the words employed in the order and grammatical arrangement in which the framers of the instrument had placed them. That is, whether we're reading contracts or wills or statutes or constitutions, they're all legal documents of the same sort from their perspective. They all need to be approached through the process of interpretation of what judges are trying to do, and the point of interpretation and the point of the judicial enterprise as it tries to understand these documents is to think through what were the people who were drafting those documents in the first place trying to accomplish, what were they saying in the rules and texts that they were laying down, and how do we unpack that and try to apply them in the situations that we are now confronting. This vision of how to interpret can lead in multiple directions. There are multiple approaches to thinking about interpretation. So Ronald Dworkin and Thomas Gray, for example, who may help make this interpretive turn among scholars and emphasize the task we ought to be engaged in as one of interpretation, were not themselves originalists. They had different visions about how to go about this process. But originalist and originalism as a theory arose within that context of that interpretive turn in which we were increasingly refocusing our attention on the text of the Constitution and how to go about trying to understand it and its meanings. And originalism has developed quite a bit from its early days as it was first being articulated in the 1970s in this modern self-conscious form. It was initially, most prominently, primarily a political project that was advanced by public intellectuals and judges and politicians, is since subsequently become very much an academic project of trying to think through in more sophisticated ways what this might mean. And that has led to some evolution and change in originalist theory itself, which continues to inform judges and others who are sympathetic to this approach to thinking about how they ought to go about their task, including some justices currently sitting on the U.S. Supreme Court. So the very heart of the originalist enterprise, though, is this same claim that we saw from Labor and others, which is to say that what we ought to do when we're thinking about the constitutional text, as we do with other legal text, is to think of it as an act of communication. And that our goal is to understand what it is people were trying to communicate when they were drafting this particular document. Now, what does that require? What the argument currently tends to focus on is what that means is we try to understand what the public meaning of this text ought to be. The emphasis of a lot of early originalists was often focused on what was characterized as intentions, and originalism was often characterized as an approach thinking about original intentions. And this shift to public meaning has in part tried to re-emphasize the importance of text, in particular as what is the object that you're trying to understand, and also de-emphasize the idea that what we were really trying to do is recapture what particular historical figures might want us to do, what they were thinking at the time necessarily. You sometimes see originalist arguments shorthanded in the form of what would James Madison do. And part of this argument of focusing on public meaning is to precisely say that's not the right question to be asking. Our goal is not to figure out what would James Madison do if you confronted him with this question at this point in time. It's not his intentions or his goals or his political aspirations that ought to be guiding us. The question is, what did the text that James Madison helped write set down in words, and what words were those communicated, what rules were being communicated over time? And Madison himself, as well as other constitutional founders, may not themselves have well understood what their own commitments were. They may not well have understood what the implications of the commitments they were adopting were. So, for example, they may have had expected applications of those rules in mind themselves. And yet, they may be informative of our understanding of the underlying rule, but they are not determinative of what the rule itself is. The core question is not how did the founders who drafted the Constitution, whether we're speaking about a constitutional text that was drafted in 1787, or we're talking about a later constitutional amendment like the 14th Amendment that was adopted just after the Civil War. The question is not how those drafters at that time were expecting that rule to be applied in practice, but instead the goal is to try to figure out what is the rule, what's the content of the rule they adopted, and then we have to exercise judgment to understand what kinds of applications, what kinds of implications might follow from that rule in the current circumstances, including in the case that's immediately before us. Early originalists also tended to emphasize the idea that part of what originalist theory is going to accomplish is to tie the hands of judges in various ways so they can't make mistakes, so they can't infuse their own policy judgments into their judicial decisions. They also tend to argue that part of what went along with originalism was a commitment to judicial restraint, such that judges ought to be deferential to the decisions made by democratic lawmakers more generally. Those kinds of commitments have been increasingly set aside, and while some originalists continue to think that originalism can help tie the hands of judges to some degree, and maybe judicial restraint might be a good idea for its own theoretical and normative reasons, they aren't necessary features of originalism itself. There are other ways of trying to limit the discretion of judges, for example. And moreover, it's also true that even an originalist judge still has to make judgment calls, still has to make choices in important ways. And even if you had a bench composed entirely of judges committed to originalism, they may not all get the same answers as to what to think about in a particular case in front of us. Instead, what originalism focuses on is a somewhat more modest goal that does not have the kind of promise that some of its early advocates might have hoped for and helped sell it as doing, but instead what originalism is primarily emphasizing is that we should not be trying to pursue the kind of project that Woodrow Wilson was advocating at the early 20th century of thinking about the court as an institution that's going to adapt our Constitution for the future, that's going to make up new rules that might help us advance our larger political beliefs and ideals. But instead, we should think of a somewhat more modest role for the court, and we should think about it being focused on a different project, not a project of thinking about what's going to be best for the nation, what's going to be best for the kind of political ideals that the judges happen to have, but instead to focus their attention on the text of the Constitution itself, the context in which it was adopted, what kinds of rules were being established in that kind of Constitution, and then doing the best they can to think through and exercise judgment in trying to figure out what might be the implications of those commitments for our current situation and for the cases that come before us now. That's not an easy task in the best of circumstances. In some cases, it's an extraordinarily difficult task. But that's the fundamental task that originalists argue, that a court charged with trying to preserve and apply an inherited constitution is fundamentally going to be concerned with. So let me turn briefly to thinking about the Roberts Court and then thinking some about what might get characterized as the future of constitutional interpretation, sort of some alternative views that are on offer at our present moment. It's sometimes thought that the Roberts Court is a kind of originalist court, and this is reinforced a bit by Justice Elena Kagan, the former dean of Harvard Law School, who is one of the liberal justices on the current court. But one thing that now Justice Kagan said before she joined the court was that we are all originalists now. That originalist arguments, just like Thomas Gray had said, we're all interpretivists now in the 1980s, Dean Kagan wanted to argue that originalists had won critically important scholarly arguments about the future of constitutional interpretation. That their point that texts hold meanings, that texts are important, that those meanings that can be found in the text are in fact authoritative and judges are bound by them and constrained by them in important ways, were winning arguments. And they won hearts and minds in the scholarly world, and they won hearts and minds in the political world. And any justice operating in the current environment should recognize that originalism needed to be part of their toolkit and needed to be part of what they were going to do as they think about applying the Constitution. So that kind of argument on the part of Kagan, that kind of assertion on the part of Kagan can reinforce the view that maybe originalism is the predominant approach in which all the justices approach the Constitution and think about it more generally. But this would, I think, be a mistake in thinking about how the court approaches these issues. Kagan herself would say originalism is one thing judges need to think about. It's one tool in the toolkit as we try to think about how to handle a constitutional case that comes before us. And in that kind of argument, I think most of the justices on the current U.S. Supreme Court would tend to agree with her, that originalism is one thing that they need to marshal, but not the only thing. And for some of the justices, it's more prominent, more important, carries a heavier role than it does for others. Justice Sotomayor might actually disagree as to whether or not originalism even ought to be part of the toolkit. But for my money, fundamentally, there are only two justices on the court that really think originalism is central to how they ought to be thinking about the Constitution and constitutional adjudication more generally. And that's Justice Clarence Thomas, who has long served on the court at this point, and over the course of his career on the court has developed his own somewhat unique but very sophisticated set of originalist understandings. He frequently is on dissent on the court, is still frequently on dissent on the court, but throughout his career has frequently been on dissent in the court, disagreeing with how the other justices understand all kinds of legal cases, but including constitutional cases. And part of how he's used his dissenting opinions is to try to develop out historical arguments about how we ought to understand the Constitution. So throughout his career, he has produced historically rich judicial opinions, trying to think through what kinds of rules and principles are actually embedded in the Constitution, which he thinks are often quite different than how the other justices approach and think about the Constitution, and it's quite different than a lot of existing constitutional doctrine would actually support and bear. And moreover, Justice Thomas is relatively radical in how he approaches this task, in the sense that Thomas thinks that if we can correctly identify what the original meaning of the Constitution ought to be, then existing constitutional law ought to fall by the wayside and be replaced by that original meaning. And so from Justice Thomas's perspective, the weight that we ought to give to existing Supreme Court precedent, that is how they decided cases in the past, the kinds of constitutional law that they've laid down in the past, ought to be very weak. when confronted with the meaning of the Constitution as construed through an originalist lens. And if existing constitutional law is at odds with the original meaning as he understands it, he's more than happy to let those old cases fall by the wayside. Justice Scalia, who was another prominent originalist on the court for many years, had developed his own theory of originalism that looked in its details slightly different than Justice Thomas's did. But one of the unique features of Justice Scalia as opposed to Justice Thomas was Scalia would have emphasized that precedent mattered a great deal more than Thomas would suggest. That is to say, even if justices were suspicious about whether or not existing case law was consistent with the requirements of the historical Constitution, there were going to be many circumstances, Scalia thought, where you ought to leave that case law in place. Even if you think in a perfect world those cases were wrongly decided and you recognize they're mistaken. On the current court, Justice Amy Coney Barrett had been a clerk of Justice Scalia, and she had spent part of her scholarly career at the University of Notre Dame as a law professor trying to develop out that argument of Scalia's, both trying to expand his argument about how to reconcile precedents that we might think are mistaken with a commitment to originalism as the primary guide to how to think about the Constitution. And her goal in trying to develop that out was a goal of reinforcing and bringing greater theoretical coherence to the kind of position that Scalia had adopted, which is one of saying that oftentimes you ought to leave those precedents in place, even if you think they are mistaken. So a much softer view about what the consequences of being a full-fledged originalist justice might be than the kind of vision that Justice Thomas has articulated. At the same time, Barrett has emphasized that originalism is the predominant approach that we ought to take to thinking about the Constitution more generally, and ultimately judges ought to be guided by trying to interpret the Constitution in a way consistent with originalism. By contrast, the other conservative justices on the court, so laying aside the three more liberal justices who may or may not think originalism belongs in their toolkit, but at least are sometimes willing to deploy it. Even if we think about the other conservative justices on the court, such as Chief Justice Roberts or Justice Alito or Justice Gorsuch, they are Justice Kavanaugh. They all have taken an approach that looks much more like former Chief Justice Rehnquist in various ways. Rehnquist was one of the early advocates of originalism, but Rehnquist was also a justice who thought that originalism was one tool in the toolbox. It was useful to use originalist approaches and sometimes was appropriate, but Rehnquist was also extraordinarily comfortable with appealing to other kinds of constitutional logic, other kinds of constitutional arguments in order to make sense of the cases that come before him. Chief Justice Roberts had served as a clerk with Chief Justice Rehnquist and inherits very much the same view. That originalism is part of what judges ought to be doing. It's one tool in the toolkit. You should pay attention to originalist arguments and originalist evidence, but it shouldn't predominate. It's not the only thing you have to pay attention to. In some cases, it may not be relevant at all. In other cases, it has to be mixed with other kinds of considerations. And to more or less different degrees, the other conservative justices tend to take very similar approaches. They may sometimes emphasize originalism, but sometimes they put it on the back burner and emphasize other kinds of concerns as well. And you see that all through the cases that the court has been deciding in recent years, where we see in part different justices appealing to originalism to greater degrees. In part, we see different lines of cases in different areas of constitutional law in which originalism plays a more or less prominent part. And so the Second Amendment jurisprudence that the court has begun to develop is in part designed to be a very originalist jurisprudence, in part precisely because there were no other prior constitutional law really guiding the court on that issue. It had not been litigated very much, not a lot of constitutional law in place, and the justices felt freer to write on an open notebook in those spaces, and Justice Thomas took the lead in being particularly interested in Second Amendment issues, and so brought to bear his originalist arguments. We also see a lot of originalist arguments at play relative to religious liberty components of the U.S. Constitution, for example. But we see originalism taking much less of a role as the court thinks about free speech questions on the court, often as the court thinks about criminal justice issues on the court, as the court tries to interpret federalism and structural features of the Constitution. Originalism may sometimes play a role, but it often plays a much lesser role than one might expect from a so-called originalist court. So prominently, for example, in the recent presidential immunity case that the court just decided involving former President Trump and whether or not he could be held criminally liable for actions that he took in office, Chief Justice Roberts writes that opinion, and it's not at all an originalist opinion. It builds on other kinds of arguments that are consistent with how the court has approached a range of other cases involving presidential power in the past by justices on both the left and the right. But there's very little originalism that was brought to bear in how the court was thinking about that case and how they tried to decide that case, which is not terribly surprising given Chief Justice Roberts' own approach and how the court has approached a lot of other presidential powers issues more broadly. So let me finally just say something briefly about what the future looks like. I think Justice Kagan is right to think that originalism has carved out a place in current thinking about how to think about the Constitution that's unlikely to go away anytime soon. That originalism will remain part of the kinds of arguments that are available to judges to make use of, for litigators to make use of in trying to develop judicial opinions more generally. And there is a set of liberal scholars in academia who in part argue that those on the political left ought to embrace a version of originalism, that in fact many concerns of the left can be advanced through originalist arguments, that those on the left ought to look more carefully at historical evidence and arguments and develop their own jurisprudence of originalism that can be embraced and advanced in general. And part of the rationale for embracing that is not just that might be appealing to current justices, but also it has the kind of democratic virtues and other virtues as a political project that people in the 1970s and 1980s were beginning to point to. Other legal scholars, though, would take a very different approach to how we ought to think about these issues moving forward. And if you had a radical enough change in the composition of the courts in larger political environment, they would prefer to make a return to something that looks much more like how legal scholars and liberal scholars were thinking about the Constitution through much of the 20th century. It's primarily a set of commitments that help advance society in ways that we think are normatively attractive. Judges ought to be exercising a prominent place in trying to adapt and modify our constitutional system in order to move it forward. There's not much space on the current court to embrace that kind of notion about how to think about the Constitution, but it remains waiting in the wings as a prominent alternative to originalism that could be redeployed and resuscitated in various ways if the political environment were more favorable to it and a different set of judges came to the fore. So I would certainly anticipate that we will continue to see a lot of arguments on the court that play in the originalist sandbox moving forward in the years ahead, but it's not impossible to imagine a world in which we return to things that look much more like the 1960s and 70s, in which judges feel empowered to be far more creative about how they go about thinking about constitutional law and what kinds of objects they're focusing their attention on when they're imagining what the constitutional law ought to look like moving forward. So with that, let me end and turn to you and see what's on your mind for potential questions relating to these or other issues of interest. So I know we have a mic, a hand mic floating around, and there's one moving down that aisle right there.
Could you address the subject of good behavior that's in the Constitution regarding the judiciary?
I'm sorry, can you repeat that?
Could you address the subject of good behavior as the term of office for the judiciary?
Judicial behavior in the judicial office. Yeah, so certainly we're seeing lots of renewed concern about how judges conduct themselves, and in particular, to some degree, Supreme Court justices conduct themselves. This has been a periodic issue of interest in American history and American politics, and I think some of that is always fed by political disagreements with the justices and the court, but it's almost always also fed by the behavior of the judges as well, and that's true, I think, in this context. The justices, some of the justices, have brought some of this on themselves. I'm thinking here particularly of Justice Clarence Thomas, who has received quite generous gifts from a variety of political patrons to supplement his lifestyle while on the bench. There's no evidence of any kind of quid pro quo or bribery scheme of any sort, and judicial ethics rules allowed, as applied to the Supreme Court at least, allowed a fair amount of reception of those kinds of gifts, but Thomas was not very transparent about how he did it, and I think it was bad judgment about how he was doing it in general, and that's certainly feeding concerns we're trying to think about. Should we adopt an entirely new code of ethics for Supreme Court justices, and is there a way of putting some teeth behind those more generally? I think there's also, beyond that kind of question about the financial activities of justices, there's also some question about their public activities more generally, and what kinds of public statements they make and the like. The justices, all through American history, since very early in American history, in part because very early in American history there was a very dramatic fight over how publicly political and partisan judges and justices ought to be. And judges have mostly retreated into being much less explicitly political, have not, for example, gone out on the campaign trail to support friends and colleagues. They don't go to political conventions and party conventions and the like. But many judges behind the scenes have often maintained friendships and engaged in various kinds of political discussions and activities more privately. We have seen some real pushback on judges recently in terms of the kind of public activities they engage in, whether it's going to Federalist Society events, giving public speeches, making statements in the news, flying the wrong flag at their second house. And that's also, I think, put some pressure on judges as to what's the appropriate sort of public posture judges ought to take. I think that one's very hard to resolve. I think it will remain extremely controversial. It's hard to develop a rule that will be very satisfactory to people. And so it's relatively easy in this environment to pluck out instances of public expression by judges that people are unhappy with, but there's a difficulty in applying that in a very consistent way across the whole range of judges. And so I think given the kinds of public expressions that we're faced with, which are not the kind that we saw very early in the court's history, where justices were literally appearing on campaign platforms with presidential candidates, it's trickier to think about, okay, what's the right set of norms and rules that ought to surround this? But I think it would be useful for judges to think more carefully about what kinds of public activities they engage in and how they express themselves in public on things that might be contested or political. So I don't know what happened. Oh, there you go. Somebody's moving with a mic in that direction. I'm letting whoever's holding the microphone just pick the people to ask questions, because you can see better than I can. Yeah.
So I know that American Samoa is currently the only U.S. territory that doesn't have birthright citizenship under the Constitution. So I was wondering, what's the constitutional significance of that, and how does that factor into other rulings and cases and how territories are treated?
That's a good question. I don't know the answer. Yeah, I actually, frankly, don't know enough about the Samoa situation in order to know that. So the basic concern with birthright citizenship, so the United States, and actually a lot of Western Hemisphere countries, are quite different than the traditional European rule about who counts as a citizen in this context. And of course, people can choose to become citizens by going through a naturalization process and passing citizenship tests and meeting qualifications, et cetera. But in the United States, we also recognize so-called natural-born citizens. That is to say that you are a citizen as a function of the fact that you're born on American soil, or you're born to parents who are themselves citizens of the United States. This is a rule that's very friendly to allowing new members into the political community. It's also a rule that avoids some of the problems that European societies have now discovered in particular, which is that you can find yourself in situations in which you have generations of people who are outside the political community and yet reside within the political community because they're not citizens, but they have lived there not only all their lives, but also previous generations' lives. But we've seen some political contestation debate lately about birthright citizenship in the context of immigration laws and undocumented aliens in particular. But I frankly don't know enough about the territorial situation in Samoa to have anything intelligent to say about that. But now you've intrigued me to go look it up, because I'm a little skeptical about this claim even, but I'm going to take your word for it for now.
So Alexander Hamilton once said that in his Federalist Papers that the Supreme Court was going to be the least dangerous branch of the three. So what factors do you believe led that the Supreme Court to become the least dangerous branch to the powerful political institution that we know it is today?
Well, so it's a powerful political institution, but it might still be the least dangerous branch. So those aren't necessarily contradictory. It's certainly a much more prominent institution than it was then and than Hamilton ever imagined. And of course, it's always worth bearing in mind that Hamilton is trying to sell the Constitution to a bunch of skeptics about the Constitution. And among the things he's trying to sell a set of them on is the idea that they shouldn't worry too much about creating these new federal courts. And the federal court system is one of the new innovations of the U.S. Constitution. The Articles of Confederation did not create a federal court system. There's a lot of nervousness about what federal courts were going to look like. Most of that did not surround problems of judicial review particularly, but instead one of the real concerns that many had is you're going to create these very distant alien courts that are going to look and feel kind of like the old British courts, and I'm going to get hauled out of my local community and go face this court on the other side of the state who is going to be unsympathetic to my interest and not understand my situation, and it's going to be terrible for me, both from a criminal justice perspective and from a civil justice perspective. And part of what the framers had to do was try to reassure people that this new court system being established by the federal government was not going to be that threatening, not going to be that troubling. And that project continued well after the Constitution was adopted. That is to say, when the first federal judiciary was established by Congress, it had all kinds of compromises built in which that judiciary did not exercise anywhere near the scope of authority that the Constitution allowed it to exercise. Congress made decisions that we're going to create a very modest judiciary precisely not to frighten people about what we're doing under this new constitutional system. So part of what Hamilton, though, is emphasizing in trying to persuade people they shouldn't worry too much about these new courts is to say courts don't really have much power at the end of the day. That you should worry about legislatures because legislatures can impose taxes on you and they can make laws that bind you. You should worry about executive branch officials because they can come shoot you or arrest you or hang you. Judges can't do any of those things. Judges, all they can do is say what they think the law means, he says. They have neither the power of force nor will. They merely have the power of judgment. And one of the reasons why that might be relatively reassuring is if we think judges go completely off the rails and are doing things that we might think are completely crazy, they have limited tools to try to effectuate their crazy. And so it's possible, for example, and people invoke Hamilton from this perspective, to imagine government officials, for example, minimizing or refusing to adhere to what judges say. That you could imagine a president saying, that the court has gotten the Constitution completely wrong. And I have a better understanding of the Constitution, and I'm not going to comply with that vision of the Constitution the court has laid out. I'm going to do something else. And here it is. Presidents, of course, have been extraordinarily reluctant to do that, and one reason why courts have been extremely powerful, have grown in their power, is precisely because presidents and other officials have instead taken the opposite approach over time and have said instead, don't ask me what the Constitution means, it's the courts that tell you what the Constitution means, and whatever they say, we're just going to go along with it, right? And that has empowered courts because the kind of judgment they exercise then has real implications for behavior by other government officials that Hamilton imagined might not occur. But that's the kind of constitutional system we have developed. And we might think actually that that's better, all things considered. We'd rather have a system in which governors routinely say, yeah, I have my disagreements, but I'm going to do what the court says, rather than governors get it in their heads that I can just ignore the court whenever I'm not very happy with it. So there's downsides of having a 2-week court. But still, that's what Hamilton would have emphasized about the nature of the judicial power itself is ultimately a persuasive power. It's a power of communicating what judges think is the law to other government officials, to elite political actors, to the rest of society, and hoping other people either agree with that they are persuasive in their arguments, or at the very least they're willing to say, you know, we don't agree, we actually think you're wrong, but we're going to go along with it anyway, because it's better, all things considered, to defer to the courts in these situations and build up a rule of law in which courts are institutions that we respect and defer to. But there are genuine political limits as to how far you can get away with that. If you really push people which is part of the rationale for sort of the development of this kind of concern about judges ought to be interpreting the Constitution, not just making stuff up, because if Mark Tushnet becomes a justice, although if we're in a world in which Mark Tushnet was a justice, it'd be a different world. But if we were in a world in which Mark Tushnet's a justice and he says, well, I'm just doing stuff in order to help socialism get here faster, not impossible, a lot of other political officials and members of society would say, well, screw that, I'm not going to pay any attention to what a court doing that is saying, and I'm just going to ignore it, or I'm going to undercut it, or I'm going to pack it, or I'm going to do various other things, right? And so courts operate within some political boundaries that are meaningful and enforceable. And one thing Mark Tushnet as a judge does not have the capacity to do and say, and if you don't like my vision of socialism, I'm going to send out guys with guns to go round you up. Hamilton would have said, yeah, exactly, right? Judges don't have that capacity, whereas if you elect a president who says we're going to bring socialism as fast as possible, he's got some guns. And so there's a downside to disagreeing with him in ways that there's not similar downsides to disagreeing with judges.
All right. I think that was a great question. Join me.
Thank you.
That was fantastic.
It's off, so.
Turn it on here. Thank you once again, Professor Whittington. That was a fantastic lecture to kick off our series for this fall. If you're interested, next Wednesday we have our next event on economic policy and whether the plans of the presidential candidates can deliver prosperity for the country. If you're interested in that, you can go to the Baker School website and click on events. It'll be held over at the Baker School in the Toyota Auditorium. So once again, I want to thank all of you for coming out tonight and enjoying this lecture with all of us. Have a great Tuesday evening. Thank you once again, Professor Whittington.